Welcome to BusinessTraining.com. This video module is focused on independent contractors. This is our agenda for the video topic today. Please take a moment to review the outline. An independent contractor is a person or business that performs services or produces outcomes or products for a business under a written or implied agreement or contract. Independent contractors are not subject to the client's control or direction, except as what is stated in the contract or agreement. Independent contractors are responsible for paying their own taxes and Social Security. Typically, the Internal Revenue Service looks at a set of factors when determining evidence for the degree of control and independence of a contractor that fall into three categories. The first category is behavioral. The IRS and courts question if the companies control or have the right to control what the worker does and how the worker really does the job. The next category is financial. Are the business aspects of the worker's job controlled by the company? How is the worker paid? Are expenses reimbursed? Who provides the tools and supplies? The final category is a type of relationship. The IRS and courts look if there are written contracts or employee benefits given, such as pension plans, insurance, or vacation pay. Is the relationship going to continue, and is the work performed a key aspect of the business? Employers quite often improperly classify what constitutes an employee as independent contractors. Whether intentionally or through misinformation, employers who misclassify employees as independent contractors do this to avoid payroll taxes, having to pay for overtime premiums or minimum wage, avoiding other wage and hour law requirements such as meal period and rest breaks, or reimbursing business expenses. Employers may choose to create an agreement with an individual or notify them of their status as an independent contractor, but this does not mean that they are not an employee. Courts will look at all factors to determine an employee-employer relationship or an independent contractor relationship, even if there is a written agreement of an independent contractor relationship. A true independent contractor does not receive employment benefits, nor do anti-discrimination or retaliation protection laws apply to them. Individuals who are classified as independent contractors but believe they are misclassified workers may file a claim or litigation to reclaim lost overtime premiums and wages and job benefits through the IRS or court system and get reclassified. Employers may be liable for fines, penalties, and back taxes and are prohibited from retaliation if it is found that the individual was indeed misclassified as an independent worker from an employee status. Employers may not retaliate because an individual questions about their employment status or files or threatens to file a claim. When individuals, employers, courts, or the Internal Revenue Service are looking to determine an independent contractor status, they need to look at numerous factors to determine the validity of an independent contractor status, known as the 20-factor test. The first factor is level of instruction. A company that directs when, where, and how work is done indicates a possible employment relationship. Amount of training is where the company requests workers to undergo company-provided training since it directs the method by which work is accomplished. The degree of business integration discusses that workers whose services are integrated into business operations or significantly affects business success are likely to be employees. The extent of personal services states that companies that insist on a particular person performing the work assert a degree of control, suggests an employment relationship. In other words, independent contractors have the freedom to assign work to anyone, and a limitation of that could imply employment, which leads into control of assistance. If a company hires, supervises, and pays an assumed independent contractor's assistance, this implies employment. The continuity of relationship mentions that if there is a continuous relationship between a company and a worker, there may be an employment relationship, unless a contractor arrangement involves continuous relationships for multiple, sequential projects. An independent contractor's flexibility of schedule and hours or days of work are not dictated by a company. A company cannot demand or control most of a person's time by requiring full-time work, otherwise it would be considered an employment relationship. Independent contractors cannot be required to work on company premises, particularly if the work can be performed elsewhere. The 10th factor is that companies that require work to be performed in a specific order or sequence indicate an employment relationship with the individual. Independent contractors should not be required to provide regular written or oral reports on the status of a project, unless mutually agreed upon in a project contract. Independent contractors are typically paid on commission or project completion, but if hourly, weekly, or monthly pay schedules are involved, it may indicate an employment relationship. Companies typically do not reimburse independent contractors for travel or business expenses, and most contractors will set fees high enough to cover these costs. Independent contractors are more often expected to provide their own tools and materials for performance of work rather than utilizing company-provided equipment. Independent contractors typically invest in and they maintain their own work facilities, whereas employees rely on their employer for work facilities. Independent contractors typically do not receive predetermined earnings and have a chance to realize significant profit or suffer a loss through their work, and they may work for several unrelated companies simultaneously. Independent contractors regularly make their service available to the general public. A company generally does not have the ability to easily discharge or terminate an independent contractor relationship, and if does so, it is dependent on the contract terms. The 20th factor is that employees can terminate their employment with a company without liability, but independent contractors cannot terminate services without liability unless specially authorized under contracts. Temporary workers, or temps, are typically hired by employers to cover for absent employees, such as those on maternity or disability leave, seasonal demand work, temporary vacations, or filling gaps in the workforce. Temp workers may be hired directly by the employer or through a temporary staffing agency. If hired through a staffing agency, the temp is on lease from the staffing company and is actually not an employee of the client company that the temp accepted work for. As the temp worker's employer, a temp agency bears the financial burden of recruiting, screening, testing, and hiring workers, as well as providing unemployment and workers' compensation insurance and any benefits that they may wish to provide, such as health insurance. Temp employees may be hired in a range of industries, including labor, education, or healthcare, and their positions may lead to permanent employment, in which a temp agency may charge a fee. This is a good way for employers to use a try-before-you-buy approach and reduce a lot of the costs associated with the new permanent hire employee. Temporary workers may work part-time or full-time, and may work for more than one agency at a time. Temps are typically not eligible for company benefits, but some temp agencies offer health care and other benefits to their temp employees. One thing employers need to note is that in some states, companies that hire temp employees may be subject to federal discrimination and harassment challenges and lawsuits. There are many pros for hiring temp workers. For employees, one of the pros is an easy hire. Employees that know they meet the technical requirements for the type of work are virtually guaranteed a job without the selection process, as they would have been through screening with the agency, and know the employer is searching for a temporary employee. Temp employees have the flexibility of hours and schedules. They may choose which shifts to work, ability to take weekends, holidays, vacations, personal appointments, or other reasons, or they may choose to work additional days for pay. Pay rates can sometimes be higher than customary wages in a comparable permanent position to accommodate fees to agencies as well as non-application of permanent employee benefits. Lastly, temp workers are less likely of getting fired as the nature of their position is so temporary, though the employer may request through the temp agency that the temp worker does not return in the future. Some pros for hiring temp workers for employers are that it enables a business to adjust more easily and quickly to workload fluctuations. In a changing economy, an unexpected growth period can call for a temporary increase in workers. Hiring temps maintains staffing flexibility and business flexibility. Employers may also evaluate a worker without commitment. As stated before, it is a cost-efficient way to recruit and test the abilities of new workers before signing them full-time, if that is the employer's intent. If the job performance of the temp worker is unsatisfactory, the employer just needs to contact the temp agency and they will do the rest. Employers will save time and money because the cost of hiring temp workers is cheaper than the cost of hiring and training a permanent employee with benefits, especially for a 6-month or less period. Temporary employees can provide specialized skills earned from working in all types of industries, bringing new experiences and knowledge to the company. Finally, hiring temp employees can lead to a long-term positive relationship with a staffing agency where they can work exclusively together in the future for company needs. There are, of course, cons to temporary employment. For employees, there are no benefits that are typically provided to permanent employees, such as health insurance, unless provided for by the temp agency. Temp to hire positions have higher turnover rates, and there is the issue of fear of job security and inconsistent work, and in a down economy, temp workers are the first to be cut. Some cons for employers hiring temp workers are there are training needs that need to be provided for those temp workers. There is a certain amount of training required for temp workers to start performing tasks to meet the specific needs of the company, no matter how skilled or unskilled they are, though this is true for new hires as well. There are morale and employee relationship issues that arise among temp workers due to working alongside permanent employees for months doing similar work and hours and not receiving the same full-time, permanent benefits of employment. Employers need to be aware of safety issues, as certain jobs are inherently dangerous and require careful safety training. Employers must ensure care is taken to see that dangerous tasks are performed safely and are supervised until temp workers can safely perform work tasks. Lastly, there are legal concerns that employers must be aware of when dealing with temp workers. Businesses must be careful how they contract for temp staff with temp agencies, and they must have no doubt about the employment status of temporary workers, as well as the lack of eligibility of benefits. Again, employers in some states may be held responsible for discrimination and harassment laws. If you would like more information on independent contractors, please go to the Internal Revenue Service website at the following link. For more information on temporary workers, please go to the equalrights.org website at the following link as well. Thank you once again for your time and attention, and this is businesstraining.com, where you can earn a master's level qualification to make more money.